Torts, Part 1. Torts require an act, intent, and causation. The act must be voluntary. This means that the physical movement must be directed by the defendant. Various levels of intent, acting with purpose to cause the consequences of the act, or knowing that the consequences of the act are substantially certain to result. Children and or incompetents may be liable if they act with purpose or know the consequences of their act with substantial certainty. There is the concept of transfer intent. And this is where you intend to commit an intentional tort against one person, but commit either a different intentional tort or that intentional tort against a different person. Looking at intentional torts involving personal injury, and this includes battery, assault, false imprisonment, and intentional infliction of emotional distress. Battery consists of harmful or offensive contact to plaintiff's person. You have intent and causation. There is no battery if there is consent to the contact, and that consent can be either express or implied. Implied is participation in an act, such as playing in a football game, where it's harmful or offensive contact. The harmful must result in an injury, physical impairment, pain, or illness. Harmful or offensive contact, the contact is offensive. If it is offensive to a person of ordinary sensibilities, this is a reasonable person standard. However, the defendant may be liable if the defendant is aware of plaintiff's sensitivity and acts regardless. The contact to plaintiff's person. Plaintiff's person includes anything connected to the plaintiff, clothing, a pet being held, bicycle being ridden, etc. The intent for battery is to act with a purpose to bring about the consequences of the act, or knowledge the consequences are substantially certain to occur. Causation, the act must have resulted in offensive harm. You may be liable where the defendant may also be liable where the defendant sets in motion a chain of events resulting in the harm. Damages for battery, there's no proof of actual harm required in battery. There is also the concept of the thin skull rule in battery, meaning you take the plaintiff as you find them. Nominal damages are available even where there's no actual harm. This is to vindicate the plaintiff's right to physical autonomy. Punitive damages may be available if defendants act. Punitive damages may be available in battery if defendant acted outrageously or with malice. Moving on to assault. Assault is an act by the defendant which causes a reasonable apprehension in the plaintiff of immediate harmful or offensive contact to plaintiff's person. Again, you have intent and causation. You have bodily contact is not required. Throwing a punch and missing is sufficient because it is a reasonable apprehension of immediate or harmful or offensive contact. Now, the apprehension must be reasonable. It may be reasonable in light of the defendant's ability to cause harm, such as their size, their skill, they're holding a real-looking toy gun, as an example. But the plaintiff, however, must be aware of the defendant's act. Gestures behind the plaintiff's back are not sufficient. In assault, you must have imminence. There must be the threat must be without significant delay. So it's an act by D which causes a reasonable apprehension of immediate or harmful offensive contact. Immediate, you have to have imminence. The threat must be without significant delay. Threats of future harm are insufficient in assault. In assault, mere words are insufficient. However, in assault, mere words may be sufficient if they're combined with conduct and/or circumstances. In assault, the intent, the defendant must intend to cause the plaintiff's apprehension, and transferred intent does apply to assault. Looking at damages in assault, no proof of actual damages is required. Nominal and punitive, as well as actual, are available. Moving on to false imprisonment. False imprisonment is an act and or omission by the defendant that confines or restrains the plaintiff to a bounded area fixed by the defendant. The plaintiff is aware of the confinement or unaware but harmed by the confinement. There is intent and causation. Looking at the bounded area for false imprisonment, the freedom of movement in all directions is limited. It's not bounded if reasonable means of escape. In false imprisonment, the method of confinement can be physical barriers, physical force, direct, indirect threats, invalid use of legal authority, and or duress. For false imprisonment, moral pressure or future threats are insufficient. Time of confinement in false imprisonment is irrelevant to the action, but may be relevant in determining the degree of damages. Intent in false imprisonment, the defendant must intend to confine P or act knowing the plaintiff's confinement is substantially certain to result. In false imprisonment, an act of negligence is not actionable. Damages for false imprisonment there's no need to prove actual damages. Punitive may be available. Moving on to intentional infliction of emotional distress. This is extreme or outrageous conduct by the defendant. You have intent or recklessness, causation, damages in the form of severe emotional distress. Now, intent in IIED, the defendant must act with the intent to cause IIED. Transfer intent does not apply to intentional infliction of emotional distress. Looking at in IIED, extreme or outrageous conduct must be such that an ordinary person would consider it outrageous. Again, an ordinary person consider it outrageous. It's more likely to be found outrageous if the defendant is in a position of authority over the plaintiff, or the plaintiff is a member of a group with known and or heightened sensitivity. Looking at third parties in the context of IIED, the defendant may be liable to a third party if the third party is a member of the plaintiff's immediate family present at the time of the defendant's conduct, or the defendant is a bystander present at the time of defendant's conduct that is physically harmed by defendant's conduct. You have causation. Defendant's actions must be a substantial factor in creating the plaintiff's distress. So causation, defendant's action must be a substantial factor. Causation in IIED, defendant's actions must be a substantial factor in creating plaintiff's distress. And that concludes part 1 of torts.